Okay, well, our music got cut short, but it's almost time to start anyway. 2 o'clock.
That was good music too. I appreciated that. I was expecting like elevator music or something.
Oh, no, I don't do elevator music. Have a whole playlist for when I do coaching stuff. So get it energized, you know?
Yeah, super fun.
Yeah. Yeah. Well, it's 2 o'clock. We might wait one more minute, just because this class may not take the full hour. I know you're disappointed that it might get out early, but we'll talk about it as long as you want. I'll try not to rush through because I want to make sure we cover everything, but because we're focusing only on paragraph 10, it should go fairly quickly. So we'll see. Yeah, here people are coming in. And I'm going to share my screen here in a minute so that we can actually see the contract provisions that we're talking about. I feel like Miss Mary Ann on Romper Room. See all my friends popping in. All right, let's get going. I think everybody knows me. And I'm happy to see you all here. When I did the post, I had the link. And then when I added the picture somehow made the link go away and I didn't realize it. So thank goodness that Cynthia commented and posted the link in the comments. So, but I see that people are finding their way here. So that's a good thing. All right. So as I was saying, we're talking about paragraph 10 in the contract today. And I call this class 10 for 10, 10 disclosures in paragraph 10. And the as is and the standard contract are almost exactly alike. There's only one difference and it's in the last disclosure. So we'll see that when we get to that part. But I'm just going to refer primarily to the as-is contract. And then when we get to that last one, I'll switch over to the standard so that you can see the difference. Does that make sense? And as we go through here, if you have any questions, just unmute yourself and ask, because when I'm sharing the screen and talking, I tend to lose track of the chat. So just chime in with your questions. So I'm going to share my screen. So give me just a moment to do that. And we're not talking about that. We're talking about the contract. Okay, everyone can see it? Are we all good? Okay, so you can see, I'm going to scroll down just a little bit, but you can see it at the very bottom. This is the as-is contract. And we are in paragraph 10 right here, disclosures. And I developed this class, probably a couple, maybe 3 years ago, because I just felt that it was not getting a lot of attention and it really kind of needed some attention because there's some really important stuff in here. So that's why we want to talk about it. Our first disclosure is radon gas. So everybody knows what radon gas is, right? It's that odorless, invisible gas that is the byproduct of radioactive decay. And it itself is radioactive. And in concentrations, it can cause a lot of health issues, lungs and all that kind of stuff, because we breathe it in, right? And it is a naturally occurring gas. It just happens because of radioactive decay. And we have it in Florida. So that's what this is all about. And that's exactly what it says. It's naturally occurring. And when it accumulates, then it can be a health hazard, right? Levels of radon that exceed federal and state guidelines have been found in buildings in Florida. Sort of good to know, I guess, to know that it's something that some people may want to be on the lookout for. The interesting thing about radon is this is all that is required. It's just a disclosure. And there's a statute that says we have to disclose about radon, but that's it. It doesn't require testing. It doesn't require anything else, only this disclosure language that is already included in the contract. And there have actually been some pretty high dollar cases on this radon issue. There was a case that was decided maybe about 5 years ago in Florida, and the issue was radon in the house, and were the buyers entitled to terminate the contract based on the radon and some other things. It went up to the Court of Appeals, and the issue on appeal was this, and whether they had properly terminated. And the holding was no, they hadn't. Seller was entitled to escrow. The big issue in the case that's memorable is that the court awarded attorney's fees for the seller because the buyers were very litigious. They were both lawyers and decided to use their profession, and hundreds of thousands of dollars in legal fees that were awarded after they were reduced from what the initial award was. So it's memorable for that, but the original issue had to do with radon gas. The next one is permits disclosure. So, you know, in the standard contract, paragraph 12 addresses permits, right? There's a whole section there where we discuss permits. In paragraph 9A, we have an amount that is allocated to permit issues that the seller is going to be responsible for. This is just talking about disclosure of permit issues. So even in the as-is contract, the seller needs to disclose that. And we start out by saying, except as may have been disclosed by seller to buyer in a written disclosure. So this is different from the property disclosure, although it could be given on that form, right? Seller doesn't know of any improvements that have not been properly disclosed. So we want seller to disclose all that. If there was anything that the seller identifies that has not been properly closed or not permitted, and we see that a lot, right? There are a lot of unpermitted improvements on properties. Then the seller is going to give all this stuff to the buyer. And here's what the seller is going to give. And you can see this at line 198. All the plans, all the written documentation concerning it. So like if they had to get HOA approval for the plans, then they need to provide that to them. Anything else that relates to that issue, the seller is going to turn over copies of it, right? Because it says, or other information in seller's possession, knowledge or control relating to all of those improvements that are either not closed out for permits or unpermitted. And it says that, it doesn't say this directly, but the implication is that the seller has met their obligation when they provide all of that information. The seller is not financially responsible for any of those permit items under the as-is contract. So that's very different from the standard contract, right? Because we have that permit limit in paragraph 9A. As-is contract, again, I want to emphasize this. The seller must disclose permit issues. However, the seller is not financially responsible for any of those issues. Does that make sense? In the as-is contract. All right. Any questions about that? The next one is mold. We're in Florida, we have mold, right? Is anyone surprised about that? I don't think so. We're just going to disclose that it's naturally occurring. It can pose health risks, right? For someone who's allergic, if it's toxic mold, all that kind of stuff, it can be very harmful to people's health, especially people who are at risk, younger children, older people, people with health conditions already pre-existing. So we go on to say, if that causes concern for the buyer, then the buyer might want to get some testing done. Now, in Florida, mold is a separate category of inspection and contractor. It's not necessarily a general inspection issue. So if just the regular inspector who comes out to do it, and if they see something that would suggest mold, they really should not be saying that. They should recommend that the mold inspectors come in, because that's a special category of licensing. The mold inspectors should come in and then give an opinion on what the situation is. Has anyone dealt with mold as a big issue in a property? So I remember 2 or 3 years ago, an instance where the inspector went, they're inspecting, they open something up and they're like, oh my gosh, it's mold, it's awful, you need to blah, blah, blah. Well, they were not a mold inspector. So of course, everyone is all alarmed. They call in the mold inspector. The mold inspector looks at it and goes, nah, it's not really a big issue. So that's why it's important to call in the experts if there's a situation regarding mold. D, this one is pretty complex. Am I going too fast, too slow? Is everybody okay?
Right. Sallie, it's Dawn. I just have a question about the mold before you go on. So if the inspector has indicated it and he kind of he strongly suggests, well, I think you should send this in. There's usually an additional charge for that. Is that just kind of as an agent, they say, well, Dawn, what do you think? How would you approach that?
Yeah, I would say if mold is a concern for you, then you would want to pursue this.
Okay.
And I would just leave it at that, because that's kind of what the contract says there at line 201. If buyer is concerned or desires additional information, so just leave it to them, you know. Okay. I mean, depending on the situation, what kind of mold is it? Do we know? If they're concerned, you know, that would be something to pursue.
Yeah, right. Because if you can't give like, my opinion is moot. It's like you either are concerned about it or you're not.
Exactly.
Okay.
And that could depend on their individual circumstances. I remember many years ago, one of the apartments my daughter rented had a mold issue, and she was sick the whole time she was there. Mm-hmm. And you know, she's like, why am I so sick? And so she kind of started looking around and is like, oh my gosh, there's all this mold here. So you know, she ended up moving for that and other reasons, and when she did, it improved. So people can suffer real health issues because of mold.
Yeah, perfect. Thank you.
Mm-hmm. You're welcome. So in paragraph D, the flood zone elevation certification, this is the only one where there's a fill in the blank. And if you look down here at line 210, remember when we have an asterisk that indicates where we need to fill in the blank. And this one, if you look on over, this is kind of a sneak preview, it defaults to 20 days after the effective date. My suggestion is always make it coincide with your inspection period, because I think it's doable. It's not necessarily that you need 10 more days or however many more days to make this happen. It's just that if you're aware of it, then you can do all those things concurrently. And that way you don't have that outlier. We talked about this a little bit last week in the as is critical dates class. Outliers are no fun because they're so easy to miss. If you have all of your due diligence within the same time period, I think it's a lot more administratively efficient, if that makes sense. It's easier to track the dates. Okay, so here's what this is, and it's pretty complicated. So let's kind of piece it out, and I'm going to be reading it because it is complicated. So first of all, we're telling the buyer, get an elevation certification about what flood zone the property is in, right? So that you want to know that because that affects a lot of things. It affects your insurance, right? And it also, this is the next part, it could affect whether the lender is going to require flood insurance, which is a big consideration. So you want to know that, right? And then the next part is, and these are all things that we're telling the buyer, you need to verify all this. What restrictions apply to improving the property, right? If it's in a flood zone area, some of those areas, depending if it's also a coastal construction area, they're going to be limited in the types of construction, the method, all of that stuff, right? So that they have the open pilings so that the storm surge can flow through rather than come up against solid construction. They're going to have that bottom, that lower level open, not really fully built out, again, because of potential flood damage, you know, so the main living areas are going to be on higher levels of the property. All of those things come into play. Next, it says, if it's in a special flood hazard area or a Coastal Barriers Resource Act area. So Coastal Barrier Resources Act are not necessarily along the coast. I remember long time ago, I was doing environmental law for Resolution Trust Corporation, if anybody remembers them. And this was when the Coastal Barriers Resources Act first came about, and there were designated areas that weren't even near the coast. It has to do more with special resources and how can we protect and preserve special resources like natural habitat and endangered species and all those kinds of things. So one of those designated areas or an otherwise protected area that's identified by U.S. Fish and Wildlife. U.S. Fish and Wildlife has to do with protecting endangered species. So if the property is in any of those specially designated areas where there may be some pretty stringent restrictions on what type of development can take place, okay? So we've got all of these if it's here, if it's in one of these areas. And then it says, and the lowest floor elevation and or flood insurance rating purposes is below minimum flood elevation. So we're talking there about the construction of the property and the flood insurance rating system. And then we have another or the property is ineligible for flood insurance coverage through the National Flood Insurance Program or private insurance. So we have the National Flood Insurance Program that is available if the community participates in the program, right? So it may not be available to individuals. It's decided at a community level. If not, then private flood insurance may be available, but we're saying none of that is available. It is absolutely ineligible for any type of flood insurance. Then, so
Sallie,
we've done this. Was that a question?
Yeah, when you say the community, you mean like if it's in an HOA or the city,
the city, the county. Yeah. Yeah.
Okay.
Thank you for clarifying. Yeah. Okay, so we've walked through all of those steps. If this and this or this, right? Now we get to the then this is what happens. And what happens is that buyer has the right to terminate the contract within the number of days that we specify after the effective date. So remember, the default is 20, and I'm suggesting make it run concurrently with your inspection period. So it might be 10, but really it's whatever the parties can come to terms on. I think administratively, as I've said, it's easier to make it run concurrently with your inspection period. And think about it in terms of expectations. If you've survived that inspection period and the buyer hasn't terminated, and then you've got another 10 days or maybe longer, during which the buyer could potentially terminate the contract because of this. I think just in terms of certainty of the contract, it makes sense to put it so that it runs at the same time as the inspection period. But that's something to keep in mind, that there's another contingency in the contract and you want to keep track of it. Has anyone ever had an instance where a buyer terminated because of this?
Nope, not me.
I haven't heard of one either. However, I would not be surprised to hear of one, just because of the way things are going, right? Okay. And then it goes on to say that, you know, if the buyer terminates, then the buyer gets the escrow back and the parties are released and nobody is liable any longer under the contract. It also goes on to say if the buyer doesn't terminate, as they could, then that means that buyer accepts the existing elevation of the buildings and the flood zone designation and everything else, including the ineligibility or possible ineligibility of the property for flood insurance. Oh, interesting. Next one is E, the energy brochure. So does everybody use the energy efficiency brochure on your transactions? It's a statutory requirement. And when I first started talking about this, a lot of people were surprised to even know about it. The brochure, you can find it online. It's not like a contract or an addendum or anything. It's not if you look on DocuSign, it's not in the Florida Realtors forms. It's just a document that you can find online by putting into your browser Florida Energy Efficiency Brochure, and you'll find it. The interesting thing is the contract, the statute says that the buyer shall receive a copy of this brochure. It doesn't say who's supposed to give it to them. So my suggestion is always, as a listing agent, maybe have that as an attachment in your listing in the MLS. As a buyer's agent, have it ready and give it to the buyers, just as part of your procedures when you work with buyers. That way, we know for sure that the requirement has been met. And you don't even have to have them sign for it, because it says in here, buyer acknowledges receipt. So when they sign the contract, they are acknowledging that they've received it. So we want to make sure they actually have received it. Questions about that? Okay. F is lead-based paint. And this is very short and sweet. Just if property includes pre-1978 residential housing, a lead-based paint disclosure is mandatory. It's mandatory because it's a federal requirement. And if it's pre-78, then you want to make sure you use Rider P, because that has all the lead-based paint disclosures on it, right? Somebody sent me a homemade lead-based paint disclosure. The other brokerage had come up with their own version of it. I looked at it, it looked like it met all of the requirements that the regulations, the federal regulations include. So it was okay. However, we really don't want to rely on a brokerage to come up with something that's federally mandated, because what if they got it wrong? And the fines on this are so high. Does anybody want to guess how much the fines are for a violation of the lead-based paint regulations for a licensee? Does anybody know? Up to $16,000 per violation. And HUD, because it's housing, HUD has jurisdictional authority, and EPA has jurisdictional authority because it's an environmental hazard, right? Lead is a toxic substance. So it's regulated under all the environmental stuff, and it's regulated under all the HUD stuff because it's housing. So each of them potentially could come in and assess fines for the same violation. So you could be looking at $32,000 per violation. And there are potentially 13 violations on that one little page, the lead-based paint disclosure. Can you all envision it, what it looks like? 13 violations on that thing times $32,000. That's a lot more than most commissions, right? So it's not worth it to mess around with it. So always make sure if it is pre-78, you include that form. And preferably it's the Florida Realtors approved form. Any questions about lead-based paint? Has anyone had issues with lead-based paint or trying to get people to sign off and initial and check all the boxes? We do sometimes get pushback from people. It's like, I don't want to sign, or I don't want to initial, or I don't want to whatever.
So what do you do in that case?
So if you can envision it at the little paragraph F where it says, it asks the licensee to initial, and it says that the licensee understands that they have an obligation to inform the seller of the seller's responsibilities and also ensure the seller complies. Ultimately, if seller balks, if the buyer balks, all we can do is say we tried, and be able to substantiate that we tried to get them to comply. Yeah, I probably a couple of years ago, there was an agent on the other side of the transaction who just was refusing to go along and do what was needed to be done on the lead-based paint disclosure. And so we just kind of had a series of email exchanges to document that. What I've seen in recent times, and I haven't looked all that recently, but there was a trend toward HUD coming in and auditing, because they do come and audit. They come and audit, and they were concentrating mostly on multifamily, because this disclosure must be given in all residential properties, whether it's for sale or for rent. However, I do have a good friend. She was in Kansas City at the time at a real estate brokerage, and they got audited by HUD, and they got fined because of lead-based paint disclosure violations. So it can happen. It does happen.
Well, they must not have had Bob as a compliance director, because that would never fly.
Yeah. Okay, paragraph G, we're on homeowners association community disclosure. Buyer should not execute the contract until buyer has received and read the homeowners association community disclosure, if applicable. So that disclosure is addendum B, the HOA community disclosure addendum, right? And that is the statutory requirement. this is a statutory requirement that we have to give this disclosure. And the statute says that the seller must provide the summary. The summary is the addendum. So when the seller provides that addendum, they have met the statutory obligation. The statute says that obviously the preferred thing is that the buyer gets that before or at the time they're signing the contract, right? If that doesn't happen, imagine that for some reason buyer signs the contract and then seller later sends over addendum B. The buyer then has 3 days during which the contract is voidable. It's not automatically void. We're not going to go that far, but the buyer has the opportunity to terminate the contract within those 3 days. So imagine for whatever reason, the seller doesn't give that addendum until like 3 days before closing.
No.
Can you mute yourself, please? There's some background noise. So if the seller delays in giving that addendum to the buyer, then that's going to open up a window during which the buyer could potentially terminate the contract. And you don't want to do that necessarily, right? I have not seen it happen with the HOA addendum. However, I have seen it happen with the condo addendum, where the seller was delinquent in getting all of those documents provided to the buyer, and they were bumping up right against closing, and the buyer did terminate because they had the right to do so. Interestingly, in the HOA addendum and the whole HOA statute and everything, all that is required of the seller is that disclosure, just that addendum. They don't have to provide the actual documents. It's on the buyer to get the HOA documents. And agents, be very careful about providing those on behalf of the buyer, because if you provide the wrong documents, the incorrect documents, they're not current, there could be potential liability for you in that situation. H, property tax disclosure summary. Oh, before we do that, any questions on HOA? No? Okay. So property tax disclosure. We all know this, right? Remember when you were in your pre-licensing class and you learned how to do all those calculations for homestead versus non-homestead and all of that stuff, right? You remember? And do you remember the Save Our Homes provision in the Constitution? It's an amendment to the Florida Constitution, Save Our Homes. And I think it's far more impactful than the actual homestead, because homestead allows you to exclude a portion of assessed value from taxable value. So yeah, you save some tax dollars, but the real thing is the Save Our Homes. Is anyone familiar with that, or you remember it? So what this does is it puts a cap on the increase in assessed value for homestead property. So let's say my neighbor is not homestead and the property tax rates are going up 10% a year. So every year their property taxes and their assessed value, right, is going to increase 10% and 10% and 10%. Mine, as a person with homestead, is only going to increase this amount. It's going to be the lesser of the percentage increase in CPI, Consumer Price Index, or 3%. So it's never going to go over 3%, right? And it could be lower than that based on CPI, percentage increase. So here I am, you know, kind of like cruising along at 3% at most, and my neighbor's going up 10%, 10%. So their taxes are going up like crazy. on their real property. Mine are going up, but not that much, right? So if somebody were to look at the public records and see my taxes and what I'm paying, they would think, wow, that's not that much. But if they look at my neighbor's property and see the actual assessment, it's going to be much different, right? So it could be significantly higher. And especially if I've lived here a long time, right? If somebody has homestead for a long time, then they're really going to be racking up those savings on the assessed value for their property taxes. Make sense? So that's what this is getting to. Buyers should not rely on the seller's current property taxes as the amount of property taxes that the buyer is going to pay. Why? Because as soon as the seller sells the property is going to be reassessed at its current value, right? So all that tax savings I've had all these years, it's going to come due as soon as I sell. And the new buyer is going to be assessed and pay taxes at the current rates and the current values. And then we say, and that's what it says, right? A change of ownership or property improvements can trigger that reassessment. And if they have any questions, it says if you, but we're talking to the buyer. If you, buyer, have any questions concerning this, contact the appraiser's office for information. So we do not want to be the ones who are giving them input on what their potential tax liability could be, right? We always want to send them to the real source of the information, which would be the county. So any questions about that? Has anyone heard of people being unpleasantly surprised and shocked at what the new taxes are going to be? I talked to somebody recently and the buyer was like totally shocked when they found out what the new taxes were. So that would be something to draw their attention to when you're consulting with people, you know, point that out to them and say, look, go talk to the people at the county, find out what your new tax liability could potentially be so that you're prepared rather than shocked. Next one is Foreign Investment in Real Property Tax Act, Ferpta, right? This is Ferpta. So think back to the listing agreement. The listing agreement brings this up. And it says that, you know, seller's going to tell us about it if this is an issue, and seller's going to cooperate to make sure that everything gets done right. I remember hearing from an agent a few years ago, a couple of days before closing, and it's like, oh, the seller just told me Ferpta. What? You're 2 days before closing and you're just now finding that out? We want to be prepared up front if Ferpta is going to be an issue. And here it says, seller shall inform buyer in writing if seller is a foreign person, because there's going to be tax liability or potential tax liability. And there's another section on Ferpta in the standards paragraph, in paragraph 18, right, where we talk more about Ferpta. The interesting thing here is there used to be a Ferpta addendum to the contract. In paragraph 19, where we list out all the addenda, if you look, I think it's in the first column on the left, and at I, it'll say reserved. That was the old Ferpta addendum. There's still some people who try to use it. Don't ever use it, because now we have the language included in the contract. There's no need to use a separate addendum. It's here and it's in standards in paragraph 18. And the withholding amount has changed. In the old Ferpta addendum, it said up to 10% withholding of seller's sale proceeds. Now the new withholding amount is up to 15%. So if you use the old addendum, I mean, ultimately, you know, the IRS withholding rate is going to prevail. However, it could be misleading to use the old addendum if somebody looks at it and goes, oh, 10%, when it's really up to 15%. Now, this one is very important at line 235. Buyer and seller are advised to seek legal counsel and tax advice regarding Ferpta. We should not ever try to make that determination. The agent who called me up right before closing, and she was on the IRS website working through the Ferpta regulations saying, well, I don't think it's going to apply. No, we don't make those determinations. The seller needs to talk to somebody. The buyer needs to talk to somebody. Although the money is going to be withheld from the seller's proceeds, the buyer is responsible to make the payment to the IRS. And so if something goes wrong there, the IRS is going to come look to the buyer. Why? Because the seller is a foreign individual. That's why this got triggered, right? So the seller, once they've sold the property, may not have any other ties that the IRS could hold on to try to get that money. So they're going to look to the buyer if something goes wrong with the payment. So that's why they need to get all of the professionals involved on Ferpta issues. Has anyone worked on Ferpta issues, had transactions with Ferpta involved?
Not yet.
Not yet. Just wait. Okay, so we are at the last disclosure. This is the
Sallie,
seller's
can I-
disclosure. This
Sallie,
sounds
can I
familiar,
ask a
right?
question?
It's everywhere in the contract. It's here. It's potentially in the seller's property disclosure that is not a part of the contract. It even says on the disclosure, this is not to be part of the contract. So don't ever include it as an attachment in paragraph 19. I've seen some people from other brokerages do that. It's in the listing agreement, it's there, it's here. Because we want to make sure that everybody is meeting the duties that they have under the law regarding disclosure. So here we go. Seller knows of no facts materially affecting the value of the real property which are not readily observable and which have not been disclosed. So who knows the famous case that came from? That is language right out of the case. It's Johnson v. Davis. That is the seller's duty to disclose facts that materially affect the value of the property that are not readily observable to the buyer or that have not otherwise been disclosed, right? So there was a later case that extended that duty to real estate licensees. So we have that same duty to disclose, just like the seller does. If we know about it, we need to say something about it, right? And then it goes on, it says, except as provided for in the preceding sentence. So that would be anything that has been disclosed, right? Regarding those material defects. Seller extends and intends no warranty and makes no representation of any type, either express or implied, as to the condition of the property or the history of the property. So that's the as is part of the property, right? As is doesn't mean that the seller doesn't disclose. It just means that there's no warranty or representation. And then we go on to say, except as otherwise disclosed in writing, seller has received no written or verbal notice from anybody about any building, environmental, or safety code violation. So that's where we get to the code violations. Now, let's look quickly at the standard contract. So here you go. Here's all of our standard contract language. Same, until we get down here. Okay, first sentence is the same. Seller knows of no facts materially affecting the value of the property. And then the last sentence is the same as our last sentence in the other one, right? About building environmental safety code violations. The one that's missing is that sentence in there about no warranties and representations, because it's the standard contract and it's different. right? Because the seller does have obligations regarding repairs and the condition of the property. So that's the difference. And it's a slight difference, yet it's very important because it gets to the seller's repair obligations in paragraph 12, up to the limits in paragraph 9A. So that's our 10 for 10, and we have done it early. Any questions about that or anything else? I'm going to stop my share.
Well, Sallie, I wanted to say something about, I think, verbiage that you wrote and Murray shared with us about a week ago. Bob and Ronnie, I have not had time to give them kudos. They brought it to us in one of our session we had with the Education Committee. And I have to tell you, it was the one about the appraisal differential. And thank you. I am so proud to be a part of our brokerage, and because it won. I use the term won. We won that list, that offer. We were not the highest offer, but because we were so organized, and he specifically said that the wording of that he was so impressed by it, and he said that they felt like they were not going to have to chase us for anything, that we gave everything right at the beginning. So
Wow.
tell you, you all thought about that and put that in our ammunition, and we were able to use it. And I know that's how we got that offer.
Well, congratulations.
Well, thank you, and congrats to you. Thank you so much for.
Thank you. Awesome. Well, that's good to hear. So it's actually working.
Yeah.
Any other questions? It doesn't have to be about this. It doesn't have to be about 10 for 10. It can be anything else that you might have questions about.
So I did have a question about the flood insurance. Is it okay to look up the flood information under MLS? It's the $25 search.
To look it up on MLS?
It's My Flood Status National Flood Search, and it charges $25 per search. Would that be something that we should suggest to our buyers?
Sure. Yeah, that would be a very helpful thing for them.
Is this before or after we sign the contract?
So you could do it either, because of that provision that would allow them to potentially terminate. And certainly if you do it within the inspection period, then even if that disclosure at 10D doesn't come into play, they would still have the option to consider it at that inspection period phase.
And also, can you tell me where I can find a copy of the energy brochure?
Yeah, if you just in your browser, type in Florida Energy Efficiency Brochure, and it should come up for you. If it doesn't, let me know, and I'll post it on the forum.
We also, this is an agent from our office, I believe, by the picture I saw. We have those in our DocuSign templates.
Oh, nice. Okay. Yeah, I was just talking with the Market Center about that yesterday, that we thought it would be a good idea to add it in.
Yep. And then I have a question on another subject. I don't know who's up. Is it me or is it somebody else?
I'm not hearing you very well. Hold, let me turn up my volume here. Okay.
All right. Can you hear me now?
Yes, I can.
Okay, getting back to Rider I regarding the Ferpta.
Mm-hmm.
We have an agent that was told by a agent from another brokerage, who was the listing agent, demanding that the buyers sign the Ferpta addendum. Demanding. Okay,
Wow.
so what are we going to tell them? I mean, I gave them an answer, but I'd like to know what you have to say.
So I would point them back to paragraph 19 and say it is no longer allowed under the contract, and all of the language is now fully incorporated into the contract. I would point them to the incorrect withholding information and suggest that if they want to continue to insist on using non-current, I'm trying to think of a good word, that, that could affect skill, care, and due diligence.
Right. Okay, good.
Yeah. And then, say it in a nice way, but wow.
Always nicely, yes.
I know.
And if they keep arguing with you, just give them Murray's number.
Exactly. Yeah. Talk to my broker.
Mhm.
Yeah.
Sallie, regarding Dawn's comment about the appraisal, you able to elaborate on that? I missed that post.
I'm sorry, I couldn't understand what you were saying.
Dawn had mentioned that they had recently won a contract based on an appraisal language, and I just wondered if you could elaborate on that. I missed the post about your recommendation.
Oh, okay. So, yeah, I can certainly find it and kind of repost it. So what it is a language that says that the buyer is willing to pay X amount of money over the appraised value, but up to a certain amount, right? So if the appraisal comes in low, we're bridging that gap. And the language specifies how much they're willing to get to bridge.
Okay, I understand. Thank you.
Yes, you're welcome. So I was talking with a colleague earlier, a lawyer, and he was asking me if I might be interested in consulting on a case he's working on, commercial transaction, breach of contract. And the problem ultimately goes back to the fact that the agent for the buyer was primarily a residential agent and not well versed and experienced in commercial transactions, and didn't fully understand what was going on, and kind of like got the buyer into a situation where they ended up terminating without justification under the contract. And so the moral of that story is, we have duties, and part of that would include what's our experience and what's our level of understanding, and don't get yourself into a transaction that's beyond that scope of experience, because it could result in horrible things like lawsuits and potentially ethics violations, or certainly ethics complaints against the agent. My dog is barking in the background, sorry. Any other questions? We can be done.
I have
Can I ask a question, even though it has nothing to do with this subject?
Sure.
I'm not sure if there's an answer regarding like something with rentals and tenants living in rental properties as a management company.
Okay, so what's
So the question would be like if there's a specific rule, specific guidelines, or specific rules for every management company that they have to abide to, or is it just individually set up, as in they can ask whatever they want? Like, can a management company decide what they say the rules are going to be for their tenants during the lease period?
They can, so long as they comply with the law.
Okay. So where would I find that written law that is within?
There's probably not one single source, but certainly it would need to comply with landlord-tenant law in Florida. It would need to comply with fair housing, because there've been. I posted this 2 or 3 weeks ago, maybe longer. Joanna Watkins, who is the general counsel of Florida Realtors, did a video, and she was talking about how there have been 48 lawsuits filed against property management companies because of screening procedures that violate fair housing. So they can't, there are limitations on what they can do with regard to property management if if there's anything that might be a fair housing issue, they can't do it.
Exactly. And is there somewhere like, can I just Google it and I'll find that law, or is
So is there a specific concern, or I mean,
for example, if the management company able to, like, say, I'll evict you if you don't let me know if you change the front door lock, just because of any situation, any funny thing, is it possible to just evict somebody from a property, rent a property?
So it's going to be so fact specific in something like that. I mean, typically there are going to be rules about, tenants not changing the locks unless they tell them, those kinds of things. But it would be fact specific. So if you want to get in touch with me afterwards, or one-on-one, I'll be happy to talk with you about it.
Yeah, sure. I would appreciate that. Do you have a phone number I can?
Yeah. I'm going to put it in the chat.
Okay, thank you.
Sallie, I have a question about mold. I recently have a pending condo and I'm representing the buyer. It was discovered during the home inspection that there was fungus of some sort from a leak from the upstairs unit into the air conditioning system of the unit. The seller did have a licensed HVAC contractor come in, remove the air handler. The leak above was repaired. They cut out the drywall, they replaced it, they put the AC unit back in. The buyer said she was comfortable with that. I asked her if she wanted to do a mold inspection by text. She said no. She's fine with the property and fine with the way they fixed it. Do I need to do anything else as far as having her sign something other than an ICR saying that she's accepting the property?
No, I mean, if you're concerned about it, I would maybe just like follow up with an email, hey, just to follow up on our text, here's the situation, and you indicated that you're fine, or however you want to word it, and maybe also leave it open. If you decide otherwise, let me know.
Okay, thank you.
Yeah.
One more question, sorry.
Okay.
Regarding the lead-based paint, I know that we have the big brochure that tells all about lead-based paint. I usually give that to the buyers. I'm now going to, after this Zoom, I will be attaching it with all my listings as well if the property was built before 1978. But there's some language in the lead-based paint addendum itself. Is that sufficient, or should we be providing that 14-page brochure?
So somebody has to provide it, because that's part of it. The buyer acknowledges that they've received it. And so, yeah, I mean, as the listing agent, attach it. As the buyer's agent, give it to them, because they have to have it. It's part of the regulations.
Okay.
Did that answer your question?
Yes, thank you very much.
Okay, you're welcome. Yeah. Any other questions? All right, so as you can see, we're being recorded, and as soon as the recording is available, I will post it just as I did with the as-is contracts, critical dates class from last week. And next week, we're talking about the differences between the as-is and the standard. So that'll be fun. And then you'll get Murray again. Because we had planned to do it like every other week. And because of the schedules for this month, this is how we did it. So you get me a couple of weeks in a row. Awesome. Well, thank you everybody for being here. I hope this was helpful, and let me know if you have any other questions.
Excellent. Thank you, Sallie.
Thank you. Bye, everybody.